Good evening and welcome back to our lectures on the Nigerian legal method. Okay, today we are looking into reasoning in the judicial process. How do judges reason in the course of reaching a particular decision or delivering a judgment? Okay, so it's important to note as a matter of introduction that prior to the advent of the legal system, disputes were mainly settled lex talionis, that is to say, an eye for an eye. If you bite me, I have to bite you back. Okay, but with the advent of the legal systems and judicial resolutions now came into place, as a form of amicable way of settling disputes between both private and corporate bodies. Okay, so it's imperative to assess legal reasoning because it is mainly concerned with the administration and dispensation of justice. How do judges go about reaching a decision based on material facts before them in relation to a particular case? That is what legal reasoning is all about. Okay, so the judicial process on its own is all about the summation of methods and processes that the judicial officer employ in administering a justice. What are those approaches employed by the judge or the bench? What are those methods? What are those rules, principles, and standards that they employ? That is what judicial process is all about. So how do they reason? How do they think? How objective are they in reaching a particular decision when it comes to judgment or matter before a court? So that is what we are looking into today. Okay, so to further go into our main topic of the day, is necessary to begin by looking at what is legal rules in the judicial process and also legal principles in the judicial process. That is, we are going to consider the variables that make up judicial reasoning in the judicial process. So simply put, a rule is an established proportion of law that is used as a litmus test to assess the issue of facts in a given case and the applicability of that particular rule to those facts. Okay, it's more like a set criteria that are used to determine whether a particular case is in line with a specific rule. Okay, and then how to go about handling that particular case based on these specific rules that have been determined. Okay, so it's usually normative and established conditions that must be made by a given case before the rule can become applicable. Okay, so there are certain elements in the case that must be related to that rule before you can apply that particular rule. Therefore, rules in general sense are prescriptive because they determine the direction of a case. Okay, the rules determine whether a case is civil, whether a case is criminal. Okay, the elements in that particular case applied to a particular rule will determine whether that case falls within a particular category of administrative sense. Okay, so if you killed someone, then the rule is that there is death, and death implies murder. So the case now falls within the element of a murder case, and so on. Okay, so legal principle, in the other hand, although they are established principles of law, they are not inflexible. Okay, they can be changed, unlike the rules that are inflexible. You can't change a rule. Once a rule has been established, it is a rule, but the principles can be changed based on whether or not the action in a particular case can alter or displace a proposition that that particular principle has set. Okay, so for instance, when two parties are of equal fault in contract, the principle becomes that they should be returned to their original state, okay, without any party claiming damage, because the abridgment of the contract was as a result of the fault of both parties. So no party should be allowed to enjoy the default of the other when the parties involved are of default on their own. Okay, that is like a principle. But in a case where the only a particular party is on default, then the other party, which is the victimized party, should be allowed to enjoy certain benefits. Okay, that is where the rule of contract comes into place. So when the two parties are at default, then the rule can no longer apply. You have to make use of the principle of law. Okay, so let us also look at the differences between rules and principles in order to be able to comprehend what we are talking about. The first is that a principle is broad and comprehensive. It covers a whole lot of things, but rules are abstract. They are made to specific legal issues or matters. They are narrowed down to specific prepositions of law. Okay, so for example, when it comes to natural justice, which is the rule of law that there should be natural justice, it has two principles. Okay, which is first is aude alteram partem. Both parties should be heard, and then nemo judes in causa sua. You cannot be a judge in your own particular case. So this particular rule is based on two arms. This principle, is based on two arms of rules. Okay, the rule number one is both parties should be heard. Then the second rule is that you shouldn't be a judge in your own case. So these two principles now form, these two rules now form the principle when it comes to the issue of principle of natural justice. So that is what we are trying to say. Rules are particular to a specific event or issue or matter. Then principle cover a whole lot of issues all within its umbrella. Okay, so for a particular matter in controversy, which is the second difference between rules and their principles, rules are usually decisive, okay, but legal principles only influence the court to act in a particular way. So when the rule says that punishment for murder is life imprisonment, that is the rule. But the principles can now be used to determine whether the murder was committed as a result of insanity. Okay, if that becomes the case, then life imprisonment shouldn't apply. Okay, so rules are very decisive. Then principles are now used to shape the direction of the court in reaching a given judgment. So the third is that courts are bound to apply rules once they apply in a given situation. But principles are just persuasive to the judge, trying to influence the decision of the judge towards a particular direction. The fourth is that rules can only apply or operate within certain conditions or precedents, things that have happened in the past. Okay, so but principles does not necessarily need to apply on any particular condition, because the judge is still at liberty to make decisions based on the weight of things in his mind. Okay, so there must be an event that must have taken place for the rules to apply, but events don't necessarily to take place before the principles can apply. Okay, so how do we demonstrate this? For instance, if you want to apply a rule of breach of contract, then the contract between parties must have been breached before that rule can be applied. Okay, so now let us look at legal standards. They make up for the certainty of the application of these principles and rules. Okay, they are the foundation upon which these rules and principles are based on. You know, they lay the outlook of what one should be expected in terms of how the court should approach cases. Okay, for example, the standard of proof in civil case is that the proof must be made on the balance of probability. To what extent is it probable that the party in question or the accused did it? But when it comes to criminal matters, then the standard of proof is that it should be proved beyond reasonable doubt. So standards are mainly the foundation upon which the applicability of legal principles and rules are based on. Okay, so you also look at legal analogy. You know, that's more or less like the way cases are related, the way a particular event in a case is related to a particular event in another case. Okay, so in a simple language, it involves investigating previous decisions to determine closeness of relationship or similarity between judicial precedent and the present case. This will now help the court to know whether to apply a particular precedent within the context of this case, or the case should now be treated on its own. Are you getting the point? Okay. So we also look at the judicial process, or the discretion, as we ought to call it. We also look at judicial discretion. Okay. To better understand what we mean by judicial discretion, it's necessary to look at the definition offered by Nemekago, okay, Justice of the Supreme Court as he then was. Okay. He defined it as the science of understanding, to discern between falsity and truth, between wrong and right, between shadow and substance, between equity and pretense, and not to do according to the ways and private affections of the judge. So basically, judicial discretion is all about common sense, reaching a decision based on what is assumed to be common sense. What is the probability? What are the substance? What are the facts? And in so doing, also make sure that you as a judge are not influenced by your own personal interest in that particular matter. Okay? So that is why we say that discretion is a two-way path. It has to be based on common sense, substantiating the substance, the fact from the shadow, falsity from truth, wrong from right, equity from pretense. Okay, and in so doing, make sure that you are not in any way being influenced by your own particular interests in that particular case. Okay, so it's important to also state that exercise of the judicial discretion is not available where there is a clear position in law as to which side the decision or ruling must go. If the law says that murder is life imprisonment, then you cannot be talking about exercise of judicial discretion, because there is a clear position as to where the direction of the decision should go. Okay, so what then is a legal reasoning and justification? To reach a particular decision, the court has to go through certain processes. It has to think about certain issues concerning the case, how it will impact certain outcomes, how it will impact the society, and so on. Okay, so there are certain factors that the judge will now have to rely on in order to justify his decision. The first is that the decision should be based on a certain authority, okay, or statutory provision or case law. You can't just wake up and rule on an issue without applying a particular rule of law. Okay, so for every decisions that are being made by the judge, they have to apply certain principles of the law. That is the first. Then the second justification is that such decisions should be made to cohere or agree with existing authorities and principles. If the case has been that punishment for murder is life imprisonment, then when you are ruling on such similar cases, it should be in line with provisions of the law, the authorities that guide punishment for murder, and so on. Okay. The second is that, considering the fact that all decisions impact individuals, it is necessary that the judge makes such decisions to be concerned with the broad impact it will have on potential litigants, the legal system, and the role of law in fostering social order and justice. Okay, so these elements have to be looked at. How will this decision impact the society? How will it impact the litigants? How will it impact the role of law? Which is why the first two principles have to be followed. It should be based on authorities, and it should agree with existing principles. Okay, that is why a judge is not expected to allow a party to keep the benefit of a contract and also claim to prejudicate it. Okay, which is the issue of contractual agreement where two parties are in default. Then they should return each other to their original states and go their own ways. Both parties cannot be in default and then one other party is also claiming damages from the other party. Okay, so that is the third justification. Then the fourth is that the judge will also be influenced by the issue of whether a decision will be in line with common sense. Like we said, discretions of the courts are based on two principles: common sense and the allegiance to legal or judiciary oaths. Okay, so where a judge is giving a decision, it is expected that the judge should not rule on a decision that would be hard to obey, because lex non cogit ad impossibilia. The law doesn't command the impossible. So the common sense there is that if this decision will result to an order that will be hard to obey, then there is no need given that particular order. Instead, it should be adjusted to make sure that when that order is made, it will be easy to obey. Okay, then finally, we have the fifth consideration, which is that in reaching a given decision, the legal reasoning and justification should be based as to whether that particular decision is in line with the common good, the greater interest of the public. Okay, what a particular positive impact will it have on the entire society? If the impact is positive, then the decision should be made. Else, then the court should consider whether or not it should make that decisions. Basically, the major reason why courts have to look into this is because it determines whether or not a particular judgment will succeed in appeal. Okay, when judgments are made out of proper legal reasoning and justifications, then the likelihood of that judgment to succeed in appeal becomes reduced, because once there are basis of law to counter or substantiate certain particular decisions from the existing principles, then the appeal will definitely quash that particular judgment. So that is why it is necessary to look into these factors in reaching a particular decision within the Nigerian legal method. Okay, so today we have been able to look at into the concept and context of reasoning in the judicial process, and then we considered reasoning in the judicial process to be based on established judicial resolutions, because previously it was an eye for an eye, but there are certain principles that have now been created to ensure that people can resolve their issues amicably. Okay, then legal rules on their own are inflexible. They cannot be changed. There are those standards or directions that the court must follow. Then the principles, on the other hand, are flexible. Once there is a higher proportion of authenticity or propensity in terms of value of a material fact to that of an existing fact, then the principle will likely change. Okay, so principles in general context are comprehensive, while rules are abstract. Okay, so the major difference is that principles are comprehensive, rules are abstract to a particular case. Okay, so for instance, we have the principle of natural justice, which is based on two rules. All the utteram patem, both parties must be heard, and nemo judes in causa sua. You cannot be a judge in your own case. There is also the fact that principles are made to influence the direction of the court's decision, but rules determine the exact direction that the decision of the courts must follow. Okay, then courts are bound to apply to rules once they are in any given case. Okay, but principles are merely persuasive. Courts can decide not to apply given principles. Then rules apply or operate within conditions precedents, things that have happened, similarity. But principles don't actually go to that extent. Then standards are those foundation of certainty that the court must now apply these regular principles and rules. Okay, analogy is the relationship between judicial precedent and the present case. How are they related so that the court will be able to apply these rules and principles? Then judicial discretion, like we said, is based on common sense and allegiance to judicial oaths, differentiating substance from falsity, differentiating shadow from truth, differentiating wrong from right. Okay, so once that is done, the court will now be able to reach a more informed decision. And then in so doing, the courts have to look at certain factors as justification. First is that the decisions must be based on existing authorities. The decisions must be in line with existing principles. Courts have to consider the overall impact of that decision on the individual. They also have to look at whether the decision is based on common sense, okay? And then they also have to look at whether the decision will bring about greater interest of public good. So thank you for today, and we will continue with outstanding lectures.